All rise.
Thank you. Please be seated. I'll get Mr. Barton back. Good afternoon, Mr. Barton.
Good afternoon.
Mr. Futrell.
May it please the Commission. Mr. Barton, have you had an opportunity to consider those various paragraphs of the statements I took you to before the adjournment?
Yes, I have.
Are you content that they are the paragraphs that you had in mind?
Could I perhaps give you a few more
Sure.
comments, if that's possible? So I think in relation to 54A, in my third statement, you'd referenced paragraphs 54 to 79.
Yes.
I would also add paragraph 33.
Yes.
In my fourth statement, you referred to paragraphs 14 to 21, and in my sixth, 23 to 33. I agree with those. I think you were joining 54B and C together.
I was.
And in relation to my third statement, I think you made reference to 22 to 53. I would also add 73 to 79.
Okay.
My fourth statement, you referred to 5 to 11 and 13. I agree with that. My fifth, I think you said 5 to 6 and 8 to 10, which I agree with. And in my sixth, you said 11 to 22, and I would add in my sixth statement, paragraph 7 to 10.
Okay. Thank you, Mr. Barton. I'll try and keep all that in my mind when I ask a series of questions, because, I mean, it is fair to say you obviously addressed the subject matter of the Riverbank investments accounts through a number of statements in the Bergen inquiry, a number of topics in the topics that you provided. So I appreciate your answers are in different places. So what I'm going to try and do is bring it together in one place, to some extent summarised. But if you feel that anything needs elaboration in order for your evidence to be complete, then please feel free to do so. But can I start by really at the beginning? So Riverbank Investments had accounts with the HSBC before the ANZ, correct?
I understand that's the case, yes.
And those accounts were closed in around 2013?
I understand that's the case, yes.
And if I understand your evidence correctly, you understood or understand those accounts were closed because HSBC had made a strategic decision to get out of the gaming sector.
That's correct.
Now, at what point during your tenure with the Crown Group did you become aware of or have reached that understanding about HSBC's reasons for closing the HSBC accounts?
My understanding of the HSBC accounts, I only became aware of that closure in the last year.
So is it your evidence you were not aware of the closure of the HSBC accounts in around 2013?
No.
Okay, and so how did you become aware of it in more recent times? Who told you?
Well, really through the material that was produced as part of the New South Wales inquiry.
I see. Now, I think in answer to some questions I had earlier regarding the opening and closing of accounts, you indicated that that was a function of Treasury.
Yes.
And Treasury reported to you as CFO.
Yes.
So are you quite sure you had no knowledge or understanding in 2013 of the closure of the HSBC accounts and the opening of the ANZ ones?
I have no recollection of the closure of the HSBC accounts.
And the opening of the ANZ accounts?
And no recollection of that either.
Can I ask you, you weren't a recipient of this email, but I've got some questions I'd like, if you don't mind, you to answer about it, just for information purposes. Can I take you to CRW.529.011.7641? And if we could also call up at the same time the attachment to it, which is same commencement but final digit 7643. Now, Mr. Barton, just for if they're up on the screen, no, they're not. Have they got? Sorry, Mr. Barton, we're having a few delays getting the documents that are up on the screen. Here we go. That's the attachment, and we have the earlier document ending 7641 alongside it, please. Now, as I said to you, Mr. Barton, you were not a recipient of this email, so I don't expect you to have seen it before. I just want to ask you some questions about who the addressees are, if you might be able to assist with that. So it has been sent to Darren Harding at crownlimited.com.sg. Are you aware of who Darren Harding was at the time?
I know he was an employee in the VIP International business, but I'm not sure what position he had at the time.
And is SG, is that a Singapore designator, is it?
I would expect so, yes.
All right. And what about Stefan? Do you know who this reference to Stefan may be?
No.
All right. What about Michael C? Is that Michael Chen, do you think?
Possibly. That would make sense.
And then there's a Plenvat at crown.com.th. Is that a reference to Thailand?
I would expect so, yes.
And do you know who that recipient is?
No.
All right. And then there's Ricky L at crownlimited.com.hk. Do you know who that may be referenced to?
That's probably Mr. Ricky Lee.
All right. And again, was he a person within the VIP International group?
Yes, he was.
All right. And then there's Joe Agahari, I think it is. Is it? Do you know who that may be?
I'm familiar with the name. I think he was also in the VIP International team.
And the next one, Alfred G.
Probably Mr. Alfred Gomez, who was also in the International VIP team.
I see. And then in the CC line, there are some areas. There's credit control, Crown Melbourne. Who would fall within that functional group?
I'm not sure. I'd be speculating.
All right. And what's funds? What's the designator funds mean?
I don't know.
I see. Cage management, Crown Perth, that seems fairly self-explanatory.
I would have thought so.
All right. And Vasula Kessel.
In the Crown Perth finance team.
All right. And Roland T, I take it that's Roland Tyler, the person you mentioned earlier in today's evidence.
I expect so, yes.
Neil De Lima.
He was a Perth-based member of the VIP team.
Indra Davis.
Yeah, I don't know Indra.
Albert Yap.
No, I don't know Albert.
Heather Ryan.
No, I don't know Heather.
Stephen H. Is that a reference to the General Manager of Cage, Crown Melbourne?
Possibly Mr. Hancock.
And Jacinta C.
Probably Jacinta Carrera, who was also in the VIP team in Melbourne.
And Philip B.
Yeah, I'm not sure about Philip B.
All right. So this, would it be fair to say this email appears to have been directed to those concerned largely with the international, VIP international business and the cage operations in Perth and Melbourne? Correct?
Yes.
And some credit control and some finance people as well?
Yes.
All right. Now, can I take you to your witness statement in this commission at 168 and 169 and ask, we also have the third Bergen witness statement, which is CRL.697.001.0033 at pinpoint 0039, where it commences at paragraph 22. Now, do I understand your evidence to be that you became aware in the early part of 2014 that the ANZ Bank was concerned that there had been suspicious transactions on the ANZ Riverbank Investments account?
Yes.
And you became aware that through discussions or communications with members of your finance team in Melbourne, that at least some of the transactions related to overseas patrons and the use of money changers?
Yes.
And I think you said earlier today your understanding of the role that money changers play was not particularly well advanced in 2014.
That's right.
Did you ask any questions at that time of your AML CTF compliance managers in Perth and Melbourne about what the significance of money changers was?
No.
Were you aware that Mr. Costin had been in communications with Mr. Birch of the ANZ Bank about transactions under the $10,000 threshold in the Riverbank Investments account?
Yes.
And you were aware that Mr. Costin had had a meeting with Mr. Birch of the ANZ Bank?
Yes.
Now, after that meeting, was it the case that Mr. Costin informed you that the ANZ Bank remained concerned about the reasons for money changers depositing cash of less than $10,000 into the Riverbank's account?
I'm not sure if Mr. Costin advised me of that. I know that he had a meeting and said that he'd provided information to ANZ in response to their questions.
But you were aware at the time that the issue from ANZ's perspective was the deposit of amounts under $10,000 into the Riverbank Investments account?
Yes.
And that one of the issues in connection was why money changers would be breaking up transactions into smaller parcels.
I think the money changers information came back in response to Mr. Costin's questions of the finance team in Perth. And I think the response was that there were overseas patrons who'd had foreign currency that they needed to convert to Australian dollars and did that with some money changers in Perth.
All right, could I direct your attention to paragraph 28 of your statement in Bergen? It's the third statement in Bergen. You had a meeting with Mr. Birch in February 2014, at which you were informed that the ANZ had decided to close the Riverbank account.
Yes.
Yeah. Now, what reason did Mr. Birch give in that conversation for the ANZ's decision to close the account?
I can't recall if he gave me a specific reason.
Well, did you ask him?
I can't recall the conversation.
All right. To the best that you can recall, was it part of the reason that Mr. Birch gave you that they had not received a satisfactory response to the questions that had been asked of Mr. Costin?
I don't recall if that was one of the things he said to me.
All right. Can I just, this may refresh your memory, CRL 0.557.001.0911, which I think is referred to in your statement. Now, I think you've made, if I could just ask you to start at the top, although it ends in the chain of emails from you to Mr. Costin on the 31st of January. But what I want to draw your attention to is that you were copied on an email from Mr. Birch to Mr. Costin at the bottom of the first page, on the top of the second page, where it sets out a series of questions in relation to the Riverbank Investments account. Could I just direct your attention to those questions that start, what is the purpose of the account, oblique, what is it currently being used for, question mark, and through to the end of that passage. Have you finished reading them, Mr.
Yes, I have.
Now, they're all fair questions from a AML CTF perspective, are they not?
Yes.
And do you remember reading this email at the time you received it in 2014?
Not specifically. No.
Having considered those questions, does that refresh your memory at all about the subject matter of your conversation with Mr. Birch in February 2014?
No, I don't recall that February conversation.
All right, well, following that meeting in February 2014, there were some arrangements made to have a further meeting with the ANZ Bank.
Yes.
And you've made reference to that in your witness statement to this commission in paragraph 171. And I think it's also referred to in paragraphs 32 and 33 of the third witness statement in Bergen. If we could have that back, please. In fact, we need to do a bit more juggling, operator, so that I just want to show you an email and a meeting agenda to see if we can jolt your memory somewhat. CRW.529.008.8581, and alongside that, please, CRW.529.001.9086. The first reference doesn't seem to be right. It seems to be the wrong. It's not, Mr. Barton's not on it. So, sorry, Mr. Barton, I'm just trying to find the right document for you. My apologies. It should be the first document should be 8582. So, do you recall receiving an agenda from ANZ around this time for the meeting they were proposing?
Yes, I recall that meeting.
And could you have a look at the document ending 9086, which is an agenda, and consider it and see if it records your recollection of what ANZ wanted to discuss at that meeting? Yes,
that looks like the content that they are proposing to discuss.
And your comment in the earlier email to Mr. Nielsen, who was the General Counsel, and Mr. Costin, is looking at the agenda, you might need more time to prepare.
Yes, I see that.
And the meeting didn't take place, did it, until towards the end of the month, in March 27th of March 2014, I think you said in your statement.
That's right.
Now, can I ask you another question? Was Christian Smith your executive assistant at this time?
Christine, she was.
Christine.
Both Michael Nielsen and I shared Christine as a PA.
All right. So can I ask that you be shown CRW.529.001.9136? And if you could draw your attention to the bottom of the first page, which is an email commencing, "Dear Josh, Deb and Travis," and it ends signed off by Christina Smith.
Yes.
Do you know if, given what you just said about the matter being she being a executive assistant that was shared between you and Mr. Nielsen, if you gave her the instructions to set up this meeting?
I don't recall. It could have been either me or Mr. Nielsen. The attendees being basically the top legal officers for each property was more in line with Mr. Nielsen's functional role.
All right. Can I ask you to just draw your attention to, there's a bullet point on the page beginning 9137 with Josh Preston in brackets, leading the discussion, please, Josh.
Yes.
Do you know if that instruction came from you for Mr. Preston to lead the instruction, the discussion?
I don't know. It perhaps looks more like the language that Mr. Nielsen might have used.
All right. Was it your understanding, though, at that meeting that Mr. Preston was to lead the instruction, the discussion on the topics?
I think I would have expected both Mr. Preston and Mr. Goney as the AML compliance officers to be part of the presentation or leading the presentation.
All right. Now, in your statement to the Bergen inquiry at paragraph 33, you've given a description in a general sense of the subject matter of the discussion on that at that meeting in March.
Yes.
And you've said there that Mr. Preston and Ms. Tagoni provided an overview of the AML CTF controls that were applied to transactions in Crown Perth and Crown Melbourne, including the controls on the Riverbank account and the South Bank account. To the best of your recollection, was there any explanation of the standard operating procedures for each of those sites in respect of transactions on the Riverbank Investments account and the South Bank Investments account?
I can't recall all of the content of the conversation.
The ANZ Bank was interested to understand the process by which transactions on the Riverbank Investments account were recorded in the psycho system.
Yes.
And they wanted to understand what controls from an AML CTF perspective were in place, particularly in this respect, in respect of the Riverbank Investments account for Crown Perth.
Yes, well, they had accounts in Crown Perth and in Crown Melbourne.
Yes.
So I think their interest was probably across both properties.
Yes, they wanted to understand the process by which the individual deposits into the Riverbank Investments accounts were treated by Crown Perth and, in the case of South Bank, Crown Melbourne, from an AML and CTF perspective, correct?
I'd agree with that.
And an explanation was given by Mr. Preston in respect of Perth and presumably Ms. Tagoni in respect of Melbourne, is that right?
I don't have a specific recollection, but that sounds right.
All right. Now, was there a discussion of concerning if there were a series of deposits for a single patron, the way in which the aggregated sum was treated by the AML, from an AML CTF perspective in each location?
I can't recall if that was discussed in that meeting.
All right. Can I ask that you, and I appreciate you were not a recipient of this email, Mr. Barton, but can I just ask you to be shown CRL.557.001.0815? And could I just draw your attention to the paragraph that commences, just to clarify in respect to the accounts, e.g. Riverbank, when multiple deposits are made, etc.
Yes, I see that.
Does that assist you to remember anything about the nature of the conversation on the 27th of March 2014?
No, it doesn't. And I guess what's not clear from this is whether that was a topic of discussion at the meeting or if this was a question that was raised after the meeting.
Well, to the best of your recollection, was it raised with you at any time?
No.
All right, now, can I just refer you to, again, to your Bergen inquiry witness statement at paragraphs 34 to 37. Now, just to get the sequence of events, understand the sequence of events, Mr. Barton, you met with Mr. Birch at the end of February and he told you that the ANZ was intending to close the ANZ Riverbank accounts.
Yes.
You met again with him towards the end of March and had some discussion around the AML CTF program of Crown Perth and Crown Melbourne.
Yes.
Was, in your mind, one of the purposes of that conversation or that meeting with Mr. Birch and others from ANZ in March to attempt to persuade the ANZ Bank not to close the Riverbank Investments accounts?
The purpose of the meeting was to respond to their concerns they were raising about Crown's AML processes. So
was your understanding their concerns went beyond the mere operation of Riverbank Investments, but to Crown Resorts Group or Crown Perth in our particular interests more broadly?
I think the purpose of the meeting was to discuss overall Crown's AML processes, which brought in both the Melbourne and the Perth properties.
All right. So you then, according to your statement in Bergen, you then had a conversation with Mr. Birch in April when you said you were going to undertake some form of review of Crown's AML and CTF program, correct?
I can't quite recall the date we discussed that, but I did indicate to him that we were engaging a third party to review aspects of our AML program.
And that eventually was Mr. Jeans and Promontory that produced a report later that year?
Not Mr. Jeans, it was Promontory who produced the report.
All right. Now, I appreciate that this has been dealt with on another occasion, Ms. Barton, but I'd like to draw to your attention correspondence involving you towards the end of April and ask you some questions about it. So the CRL .605, .016, .4170 and just make sure I've got the right, yes, that's the right one, I think. Again, this is a chain of emails, Mr. Barton. You were not a participant in the final couple at the top, but further down, you were copied on an email from Mr. Costin to a number of people, which appears at about 3/4 of the way down the first page of the email. And it makes reference to, if I could just draw your attention to the last page.
Yes.
Where notice is given that ANZ will be closing the Riverbank Investments account. And there's a reference also to closing some accounts of South Bank investments in Hong Kong and Singapore.
Yes.
And in the next paragraph is a reference to transitioning to the CBA account and an instruction, can customers be advised by relevant people that multiple cash deposits in branch under 10,000 reporting threshold will not be accepted in the new CBA accounts.
Yes.
Now, to the best of your knowledge, was any procedure put in place in the standard operating procedures or by some other means to prevent multiple deposits under $10,000 being deposited into the CBA accounts?
My understanding was that notification was given to all customers that it wouldn't be accepted, but I'm not sure if that was incorporated into SOPs within the business.
Do you know whether, to your knowledge, it was incorporated into any internal audit program to see if there was compliance with that instruction?
I don't know.
In your view, who within the Crown Resorts Group had responsibility for giving effect to that instruction?
It would be the operating business that interacted with the customers.
And who does that? What does that mean?
To the extent these accounts were being used for VIP patrons to communicate to the VIP patrons, which would have been most of the activity in the account.
And what about, in your view, was there anyone, having given that instruction, I should say, withdraw that, having given that instruction, was it your expectation there would be a formal procedure put in place to ensure it was adhered to?
My expectation is the business would ensure that was the case, but I didn't turn my mind to what that would have translated to in terms of a procedure or a policy.
Did you consider it within your part of your responsibility to ensure that a procedure was put in place to prevent cash deposits under the threshold being made to the CBA bank account? Multiple cash deposits?
No.
Did you consider that to be within the remit of the AML CTF compliance officer?
No, I would have expected that to have been somewhere in the business unit. Perhaps not the AML compliance officer, perhaps the business unit that interacted with customers.
Would that be the cage?
Possibly the cage, or possibly the commercial team in VIP.
Do you mean the sales team?
The sales and with the commercial team as part of that conversation.
Now, can I just ask you to look at, I think it's paragraph 72 in that statement, same statement, which is your third statement. Now, part of your statements obviously dealt also with measures that Crown was taking in the course of during the Bergen inquiry and earlier to address some of the AML and CTF issues. And you indicate there with effect from 8 April 2020, Crown determined that it would no longer make or receive payments from third parties without prior notice and approval. Do you recall why that step was taken in April 2020?
Not specifically, but I think there were concerns about the ability to do sufficient due diligence on payments that were received or made to parties other than our customer.
All right, so this is dealing with a slightly different topic to the multiple deposits, is it not? This is about whether or not an amount is transferred to a third party by, let's say, from a patron account to a non-related party.
Correct.
And was there any event that had taken place that prompted Crown, from your perspective, to take this step in April 2020?
That was initiated by the business, and I can't recall if there was a single event that led to that decision.
All right. Now, going back to the events in 2014, it was within the within the power of Crown Perth in 2014 to put in place a system whereby they would not accept cash deposits in the Riverbank Investments account.
Whether they could prevent it, I'm not sure, or whether they would need to put in place processes to deal with it if it did occur.
Yes. So taking the first step, you couldn't stop someone depositing a cash amount into the account, most likely.
I think that's the case.
But you could put in place a procedure that indicated if such a deposit took place, the funds would not be available to that patron for gaming purposes.
Yes.
In other words, Crown could have put in place a policy whereby it did not accept cash into Riverbank Investments account or any of its other accounts for gaming purposes.
Yes.
And the third party procedure that was implemented in April 2020, that could easily have been put in place at an earlier point in time as well, could it not?
Yes, it could have.
And can I just take you back to your statement at 72B? And there's a reference to a maximum amount of cash that a junket can deposit at the cage in any given day of 300,000. Again, that's a policy that could have been implemented at any time by Crown Resorts, isn't it?
Yes, it is.
Now, you might recall in one of the documents I took you to earlier, there was a reference to a decision by ANZ not only to close the Riverbank Investments accounts and the Southbank Investments accounts, but also some accounts that Southbank Investments held in Hong Kong and I think Singapore.
They didn't have a Southbank account with ANZ at the time.
They were accounts of Crown Melbourne, were they?
They had accounts of Crown Melbourne, yes.
Was it, and do you recall that Mr. Hancock expressed some frustration in that email to you about the closure of those overseas accounts?
I'm not sure if it was frustration, but I know that those accounts were important to the business.
Yes, they wanted to have overseas accounts available for their patrons to deposit funds into overseas.
Correct.
And was it your intention in 2017 to open accounts in the name of Riverbank Investments with the Bank of China overseas?
There were discussions with Bank of China about potentially having transaction banking relationships with them, although that never proceeded.
All right, so why did it not proceed?
I can't recall why it didn't proceed. I think it was discussions we're having with them generally about a relationship, and no aspect of that relationship ever eventuated.
Did, to your knowledge, Riverbank Investments attempt to open accounts overseas with any other institution?
Not to my recollection.
Okay. Now, Mr. Barton, I think it's fair to say that in a number of the statements you made during the Bergen inquiry, you made some acknowledgements about the nature of the promontory engagement in 2014, and I think you acknowledged it wasn't an adequate response to the ANZ Bank's decision to close those accounts in 2014.
Yes.
I don't intend to take you back through all of that again, Mr. Barton, but I do want to ask you some questions about the steps that were taken and your views about the reasons that responses were not as fulsome as they may have been or could otherwise have been. So if I could draw your attention to paragraphs 39, or sorry, essentially 38, 39 and 40 of your third statement in the Bergen inquiry. And so in 38, you address the findings of the promontory report, but I think you acknowledge that it didn't really take into account the concerns that ANZ Bank had raised in that year about the operation of the Riverbank Investments account. And then in 39, you set out some responses that could have been taken. 39A includes a thorough review of the Riverbank Investments account and other patron accounts controlled by Crown Perth and Crown Melbourne. To your knowledge, up to the point in time that you left the Crown Group, was a thorough review of the Riverbank Investments account of the kind described in 39A undertaken?
Yes.
And are you referring to the reviews undertaken towards the end of 2020 by Initialism and Grant Thornton? Is that, and the process that commenced then?
Yes.
And is it your evidence that it was completed by the time that you left the Crown Group?
We'd received reports from Grant Thornton and Initialism on the Riverbank and South Bank accounts. Yes.
All right. Now, that process, is fair to say, did not commence until towards the end of the Bergen, September, or around September 2020, correct?
Probably October.
All right. So it took some years, it's fair to say, before anyone in Crown Group undertook an investigation into the operation of the Riverbank Investments accounts.
Certainly an external investigation, yes.
I'll come back to the steps you took, Mr. Barton. Can I just draw your attention to 39B? And the step is an immediate escalation to Mr. Preston and Ms. Tagoni as the relevant AML compliance officers. They were in the meeting in March 2014, were they not?
They were, yes.
So, I mean, they were well aware, were they not, of the nature of the concerns of ANZ Bank?
Certainly as no later than March 2014.
All right, so that effectively is a step that was taken in 2014.
Yes, although between January and March.
And that didn't result, to your knowledge, in any internal investigation of the Riverbank Investments accounts?
Not to my knowledge, no.
Now, can I just draw your attention to 39G, where you reflect on the instruction to not deposit amounts below the 10,000 threshold. And you make a reference there, this is because I can now see that it was unlikely to be an effective response to the root cause of the problem. In your view, what was the root cause of the problem?
It was the ability for patrons to deposit cash into our bank account without our ability to, in a timely way, either identify it and reject it or prevent it. And then those funds being available to patrons to transact with the casino.
In the period during which you were employed in the Crown Group, do you understand that there have been any investigation undertaken to ascertain the root cause? The reason why, if you like, not only were the deposits made in this way, but seemingly the AML monitoring didn't pick them up.
Well, I'm not sure about the last part of that question, Mr. Futrell, the AML monitoring not picking them up.
Well, is it not the case that there was an aggregation of amounts that were deposited into the Riverbank Investments account by Cage staff?
Yes, there was for a period an issue with a process of aggregating the deposits, yes.
And then when it was reported in Psycho, the AML team were unable to identify the individual transactions from an AML monitoring perspective.
That was an issue that arose, yes.
So what I'm asking you is whether there was an investigation during the period you were employed by in the Crown Group of the root cause of that event, why there was aggregation and why there was therefore the inability for the AML team to undertake the monitoring correctly.
Yes, there was a review that was commissioned. When I left, it wasn't complete, but that piece of work was within the scope of some work that was being done by Initialism to understand the root cause of the aggregation issue.
Now, the Initialism report revealed not only some difficulties in respect of some typologies in relation to money laundering of so far as structuring and other characterisations go, but they also identified transfers to third parties unrelated to patrons, didn't they?
I'm not sure if that was one of the issues that they identified in their report.
I'll come to that in a moment, actually. It's probably easier to do it when I deal with some of the... I'll come back to that, Mr. Barton. Now, again, to understand the sequence of events, Mr. Barton, sorry, just before I deal with it, you've made a point, I believe, in your statements to Bergen Inquiry that you formed the view that Crown was focused on compliance in this period, in the period of the Riverbank Investments, sort of 2013 to 2020. And do you mean by that, sorry, this is to go back to your statement, it's in 40B. Do I understand from that what you're saying? The view you're expressing is that at the time, that Crown was really focused on strict compliance with the letter of the law, but not the spirit of the law.
I think complying with the obligations under the AML-CTF Act, I think my point there is that continuing to see particularly suspicious matters that are reported should at some point prompt somebody to look at that more broadly and say, are we seeing behaviours here that are indicative of the wrong kinds of customers?
One of the things you identified in your statements in the Bergen inquiry was a more recent emphasis on prevention, if I could put it that way. So you've taken some time to step through the changes that were being implemented during 2020 with an emphasis on prevention.
Yes.
Is it your view that prior to those steps in that period, where steps were taken for prevention purposes, the focus of the Crown Group was really on compliance and not prevention?
I think we were building capability from about 2018 onwards, but I don't think it was until more recently that we were taking very active steps to try and prevent the sorts of transactions that we've seen go through those accounts.
And do I understand from your evidence that in 2014 there was no report of the closure of the ANZ account or the reasons for it to any board within the Crown Group?
That's correct.
So it evidently did not occur to anyone who knew of that the closure of the account may be an indication of a heightened money laundering risk that ought to be elevated to consideration at the board level.
Yes.
Now, you're aware that there were some allegations made in the media in the middle of 2019 concerning, amongst other things, the Riverbank Investments accounts.
Yes.
And you've addressed that at some length in your Bergen inquiry statements. And do I understand from that you've largely given evidence based on your conversations after the event with Ms. Lane and Mr. Preston about what steps were taken in 2019 to investigate the Riverbank Investments accounts?
I did have some contemporaneous knowledge in 2019, and then some information that I obtained afterwards.
Did you understand in 2019 there to be anyone within the Crown Group undertaking a review, as in looking at the transactions on the Riverbank Investments accounts? I think we may have lost Mr. Barton.
I don't know if it's significant, but it happened at 3 o'clock.
Yeah, it was right on the. It's when the meter ran
maybe
out.
we had a booking till 3 o'clock.
Oh dear. Shall we adjourn and find out what the...
I think we will. We'll need to take a break for the transcribers, so
All right.
it's probably wise to take a break now.
Oh, hang on.
I'm sorry, Commissioner, I've put in a call to see what's happened with Mr. Barton.
Right, we'll Ms. Boris, we'll break for 10 minutes and see if we can resume the link. So we'll just break for 10 minutes. Thank you.
Thank you, Commissioner.
All rise.
be seated. Yes, thank you, Mr. Barton. Thank you.
Apologies, Commissioner.
That's all right. Mr. Futrell.
May it please the Commissioner. Welcome back, Mr. Barton.
Thank you.
I just asked you a question before we lost you regarding whether, to your knowledge, any person in the Crown Group was undertaking a review of the Riverbank Investments account specifically in the middle of 2019.
Yes.
And I'm talking about your knowledge in 2019 now, not your
Oh,
knowledge.
in 2019. There was some work being done in relation to the allegations in 2019.
Right. Now, were you aware in 2019 of the specific nature of any investigation or review by any person within the Crown Group of the bank account statements of Riverbank Investments?
In 2019?
Yes.
No.
Did it occur to you that it was necessary to undertake such an investigation in 2019?
Not at the time.
Now, after the allegations were made public by effectively the Fairfax Press, and I think 60 Minutes may have dealt with this as well, you had a meeting with the CBA to discuss the Riverbank CBA account.
Yes, that's right.
And you were given some information at that meeting that the CBA couldn't share with Crown, but indicated that they wanted to have an understanding of Crown's AML controls.
They didn't give us information, but they did want to have a meeting with our AML team to understand our AML processes, yes.
Yeah, and I take it you understood from that meeting that the concern of the CBA Bank centred on money laundering through the CBA Riverbank Investments accounts.
Yes, I understood that Louise Lane, who was our AML manager, had been meeting with CBA to discuss our AML processes.
But you understood that their concern was relating to operation of that account in a way that may lead or facilitate money laundering.
I'm not sure they were as specific as that, but that would certainly be an assumption you could draw.
Yes, but in terms of what you understood, what you put two and two together, I presume, and understood the concern to be in relation to money laundering.
Certainly that would be something that would be in my contemplations.
It was in your contemplation, wasn't it, in 2019? That was the reason.
Yes.
Now, in your statement you have mentioned that notice was given to the Burswood Limited Board and I think to the Crown Resorts Limited Board of the closure of the CBA accounts.
And the Crown Resorts Risk Management.
Yes, there's a reference in your statement to that, yes. Now, to your knowledge, at any of those meetings in which you participated, whether it be Burswood Limited, Crown Resorts or the Risk Management Committee, was there discussion around the reason for closure of those accounts?
I recall there was some discussion at the Crown Resorts Risk Management Committee about the environment for access to banking arrangements.
And was there a reference there to something that Ms. Holton had to say about that?
I think that's right, yes.
And so was it the case then at the Risk Management Committee meeting there was discussion about closure of the accounts because of AML CTF concerns?
I can't recall if it was in that level of detail.
All right. Well, could I just ask if you could have a look at CRW.507.004.5742. and at pinpoint 95916, I think it is. You see at the bottom of the page there's a reference there to Jane Holton noted that the closure of the Commonwealth Bank seemed.
Yes.
Are you able to elaborate on what the nature of the discussion was at the Risk Management Committee meeting?
No, I can't recall.
Do you know if after the closure of the Riverbank investments accounts in 2019 there were any steps taken to open accounts with another institution?
In the name of Riverbank or South Bank?
Yes.
Not that I can recall any attempts by Crown to talk to banks about opening new accounts.
I beg your pardon, I missed that last part of your...
Not that I can recall any conversations that Crown had with banks about opening new accounts in those names.
All right. Were there conversations within Crown Group itself, the Treasury team, for example, to see if further accounts could be opened?
Not that I can recall.
Now, can I just ask you to be taken to your sixth statement in the Bergen inquiry in paragraph 12. And I just want to establish, if I may, Mr. Barton, the point at which the Crown Group turned its mind to and reviewed specifically the Riverbank investments accounts. And am I right in thinking, or do I understand correctly, that leaving aside the discussion you had with Ms. Lane, where her review didn't lead to the appointment of external consultants, it ended, that the first time, to your knowledge, that a person within the Crown Group reviewed the Riverbank investments accounts for the purpose of considering if there had been any structuring or typologies of money laundering was after you prepared your third statement, which is so after 16 September 2020.
Yes.
Can I ask you to be shown CRL.663.001.0001? Now, do you mind just allowing Mr. Barton to have a look at the letter? I just want to know if you remember receiving that or reading it in 2020.
I don't recall seeing that letter. All
right. So I note it's not mentioned in, I think, in your witness statements, any of your witness statements for that matter. So is it your evidence that you were not made aware of a letter from Mr. Preston and Mr. Stokes to Austrac in August 2020?
No.
And so, just a matter of interest, Mr. Barton, have you seen the letter before today at all?
I believe it was in the witness bundle maybe yesterday or the day before.
And is that the first time you can recall seeing this letter, is it?
Yes. Now,
in your statement, Mr. Barton, you've made reference to sending an email to the Board of Directors on the 29th of September, attaching a memorandum that Mr. Murray prepared for you. Do you recall that part of your evidence?
Yes.
And I think we may have been through this relatively briefly earlier today, but did you understand from Mr. Murray's review, that he had identified a number of instances of multiple deposits under $10,000 within a 72-hour period into the Riverbank investments accounts?
I think Mr. Murray's analysis was focused on the issue of aggregation at the time.
Yes, and did you understand that he identified a series of transactions over a 72-hour window period, all of which involved aggregation when the amounts were recorded in Psycho?
Yes, that's correct.
And at the time, I'm referring to September 2020, were any steps taken at that time to identify the reason for the aggregation in the way in which the cage operated during that period?
I recall a conversation with Mr. Preston where he was having a conversation with the heads of the cages in both Melbourne and Perth to understand the reasons for that occurring.
All right, and what did Mr. Preston's explanation, what was his explanation for the reasons it occurred in Crown Perth at least?
I think at the time he didn't have an explanation. They couldn't understand why that process would not have followed the normal procedure, which is to record each transaction separately in Psycho at the cage.
And did you yourself have any conversations directly with the general manager of the cage in Perth and Melbourne about this matter?
Not in Melbourne, but the head of the cage in Perth, Mr. Brown, was in Sydney, and I asked him if he could explain it, and he had no explanation for why that would have occurred.
And insofar as your conversation with Mr. Brown was concerned, did he describe to you the process he understood that the cage cashiers were to follow?
I don't recall if he went into that level of detail.
Was it your understanding after your conversation with Mr. Brown that the cashier process was recorded in some operating procedure, for instance?
Yes, I understand there is a mandated procedure for recording cash deposits.
And was it your understanding that they were to not to aggregate in that procedure and to record individual transactions? Is that your understanding?
That's my understanding.
And what about the, irrespective of the aggregation question, the absence of anyone within the cage identifying that the multiple deposits within a short window of time may be an indication of money laundering and therefore a need to raise a suspicious matter report?
I didn't have that conversation with Mr. Brown about that.
Now, Mr. Barton, you provided a presentation to the Gaming and Wagering Commission in Western Australia in October 2020.
Yes.
And can I just ask, we call it CRW.709.136.4783, which I think is referred to in your statement, Mr. Barton. Now, I've been through this, Mr. Barton, and I would like to ask you whether in the course of your presentation to the GWC, you provided any explanation for the reasons for the closure of the CBA account.
Not that I can recall.
So the presentation notes that they were closed in December 2019, but there's no reference to it being closed because of or by reason of concerns about an AML CTF perspective.
Other than, if I recall correctly, I can't with precision recall, but that was a comment in relation to Crown's processes around AML CTF.
I'm just wondering if there was any discussion, if you made plain during your presentation to the GWC that it wasn't at the initiative of Crown Resorts, for example, to close the accounts. It was because the bank decided to close them itself.
I can't recall if that was part of the presentation.
And again, I don't remember seeing any reference in there to the issue of aggregation of deposits into the Riverbank Investments account and the inability of the AML team to monitor those in the presentation to the GWC. Was that the subject of any discussion during the presentation?
I can't recall.
It's fair to say there's a focus on the future, I suppose, in terms of the presentation and what steps Crown was then taking to address things. In fairness to you, Mr. Barton, did you have an understanding or appreciation that the GWC may have been following the Bergen inquiry quite closely and the revelations that were taking place throughout 2020 before you met with them?
I'm not sure, Mr. Future. I offered to do a presentation to the GWC on whatever topic was considered relevant. And this was the material, I think, that was viewed as being relevant to of interest to the Commission.
So the focus wasn't really on, if you like, past failings, things that happened in the past that you were seeking to redress. It was really just on the redressing component. Is that a fair assessment then?
I can't recall all of the content, but part of the future was also acknowledging the issues that have been surfaced through the course of the inquiry.
And in the nature of that acknowledgement, was that expressed during the meeting, or was it taken, as I say, was it taken as implicit they knew because they'd been following the Bergen inquiry?
I think to introduce the reform program, it needs to be in the context of these are issues that have basically been brought to our attention through the course of the inquiry. So
is it fair to say then you were taking it as read, there were issues that needed to be addressed, and this is how you were addressing them?
I'm not sure I'd take it as read, but certainly this was a presentation in response to issues that we'd identified.
And in the nature of the, how long was the presentation with the GWC? How long did it take?
I think I recall perhaps half an hour.
Were there questions from GWC members to you about the subject matter of your presentation?
I can't recall.
I think you did a second presentation in December 2020. Was that in person or via Teams or something?
That was in person.
All right. Can I ask that you be shown CRL.513.021.6263? Now, this is a letter, begins with a letter that was sent, I think, to the GWC the day before the meeting. It's quite a long letter, Mr. Barton. Were you involved in the preparation of that letter?
I did see a final copy, but I wasn't part of the group that actually prepared the letter.
So when you say you saw a final copy, was this sent with your, or signed by you, so presumably you sent with your approval?
Yes.
Now, it obviously, it expands a little bit on the nature of that earlier presentation in October 2020 and gives a little more detail, including attaching copies of Grant Thornton's work and Initialism's work to this point in time.
Yes.
Obviously, the members of the GWC, having received it the day before, given the length of the document, may not have had an opportunity to fully familiarise themselves with all of those annexures.
No, of course.
How long was your presentation on that occasion?
I think, again, it was perhaps less than half an hour.
All right. Did you take them to any of the attachments, in particular I'm thinking of the initialism report and the Grant Thornton report, and identify for the members the key findings in those reports?
No, I don't believe it.
So again, was the focus then of this presentation on the future and what steps you considered that Crown Resorts was taking at that time to address, if you like, past failings?
I think for that meeting, we didn't come with a prepared presentation. It was more of a discussion, and it was open to discuss any topic, but as it eventuated, most of the conversation was about the reform agenda.
All right. And was that the nature of the presentation you gave then on what you were proposing to do looking forward?
I think most of the discussion was about the things we were doing to remediate the issues.
Okay. I said to you earlier I'd take you back to something which I just, because it occurs in, it's referred to in, I think it's the initialism, extended version of the initialism document. I'll just give you one example and I'll ask you a question about it. If I could ask the operator to take us to pinpoint 0696. Sorry? All right. I understand they're reconfiguring the screen, Mr. Barton. The doc ID is, sorry, I'll give them the wrong, I'll give them the wrong page reference, that's why. The actual, it's CRW 0.513.021.6263, and the page reference, I'm sorry, is 6353. It's got two doc ID, that's the problem. Okay, you need to scroll down the page to underneath the heading PID. Yes, that's it. And I just want to. There are a number of these summaries attached to this report, Mr. Barton, but I just want to draw your attention to the third last bullet point on that page. And there's a reference there to the release of funds occurring and a patron not signing. And you might recall a little earlier I asked you a question around the explanation for the change in procedure in April 2020 concerning third-party transactions. Is it your understanding that prior to that change being implemented in 2020, a patron could essentially give an instruction to the cage to transfer funds held to the credit of the patron in the psycho system to any third party?
I'm not sure what the process was before that.
All right. But did you read this report when it came in from Initialism?
I did read it, yes.
And did you understand from the contents of it that there are a number of typologies of potential money laundering that are identified, not only those that were identified in respect to the Riverbank Investments account itself, but the possibility for transactions to third parties to be used for money laundering purposes?
Yes, I think that's right.
And so if, for instance, if a patron is able to transfer to a non-related third party funds, that can be an indication of money laundering.
Yes.
Up until the point in time that your employment with the Crown Group ended, do you know of your own knowledge if any investigation has been undertaken or inquiry is being undertaken with respect to identifying any transactions, historical transactions to non-related third parties where the relationship between the patron and the third party cannot be established?
Not to my knowledge.
Mr. Barton, I would like to take you to a document that you may not have had the opportunity to read. We referred to it quite late yesterday. It's DTT point quadruple zero point 0005 point 0009. This is a statement by Ms. Whittaker given, we understand, to the Victorian Royal Commission. And in it, a number of statements are attributed to you. I could take the pinpoint is 0016. Now, I understand from reading this document, and you can correct me if I'm wrong about this, that towards the end of 2020, you as CEO of the Crown Resorts, commissioned Deloitte to undergage an assessment of Crown's cultural framework.
Yes.
And as part of that assessment, you were interviewed by Ms. Whittaker.
Yes, that's right.
And can I just draw your attention to, on that page 16, there are paragraphs 71 to 78 attribute statements or views to you. Could you just read those and confirm that they actually reflect your view?
I've read that, yes.
And is that consistent? Did you accept that as an accurate representation of your views in December 2020?
Well, I think the conversation with Ms. Whittaker was more asking questions of things for Deloitte to investigate rather than an expression of my perception. So some of those are worded that way. Others should have been worded that way. That it was a question of, are these issues? And as part of their review, could they explore and examine whether these issues were real?
All right. So if you take the 71, for example, is that an accurate representation of your view or not?
Well, I think the first sentence was an observation.
Yes.
The second sentence was more in the nature of a question.
And so,
Rather, yeah, is there a culture that is reactive to risk and people raising things but not continuing to raise risks?
okay. And 72?
Again, the wording there is there are perceptions, and it's more, is there any accuracy to those perceptions, or is there a question that needs to be answered about people holding others to account?
73?
Again, that's a question.
And does that apply?
The second sentence obviously is factual, but the first sentence is more in the nature of a question.
All right. And the 74 in the same character, is it?
Yes.
75?
Yes.
76? 77, sure, that's a view you expressed at the time and would adhere to.
Yes, I agree.
Now, in relation to 78, which does appear to be expressed in a more investigative way than the other ones, you've expressed a desire to focus on the VIP business when examining subcultures, with a view they may have focused on revenue generation and sales. Is that you expressing a view that the VIP business requires specific attention because of its focus on revenue and sales as opposed to compliance?
My view was that there was a particular focus in the VIP business about revenue generation, and perhaps a greater tolerance for risk, although I'm not sure about a real focus because the business basically was shrinking by the time we got to the end of last year. Okay.
Now, your employment with the Crown Group came to an end in February this year, is that right?
That's correct.
And do you continue to have any role or relationship with any entity in the Crown Group today?
Yes, I've got an arrangement where I'm available to provide services as needed.
And is that some form of consultancy agreement, is it?
Yes, it is.
And do the terms of that agreement require you to advance the interests of the Crown Group?
No.
What is the scope of that arrangement?
I'm available to respond to any issues that arise in relation to any of the work that was underway when I left employment.
So does it take into account the various reform proposals that you had implemented under your stewardship?
Yes.
Does it include dealing, for example, with the various royal commissions that are taking place?
I can't recall if that's specifically included.
All right. May it please the Commissioner, I have no further questions.
Thank you, Mr Futrell. Are there applications for leave to ask questions of Mr Barton?
Please, Commissioner, I seek leave to ask cover three topics.
Mr Penglis.
Very short. Thank you. Mr Barton, my name is Penglis and I appear for Mr Preston. Mr Barton, A short time ago, you gave evidence of a conversation with Mr. Brown on the aggregation issue. Do you recall giving that evidence?
Yes.
Can you expand a little further on that conversation? Firstly, it's a conversation that you had after the conversation with Mr. Preston.
I can't recall if it was before or after.
All right. So this is a conversation about 10 months ago. Is that fair?
That's probably right.
All right. Where was it? You said it was in Sydney. Was it
Yes.
face-to-face or by telephone?
No, it was in the Crown Sydney offices.
All right. And what did you say to him, to the best that you can recall?
It was a relatively short conversation. I asked him if he could explain what the cause or the issues were around the aggregation, to which he said he couldn't explain it.
When he said he couldn't explain it, did he give you any understanding as to his views as to whether or not it was something that should have or should not have happened?
I think it was clear in the way he expressed it that it was something that shouldn't have happened.
All right, thank you. Now, I want to ask you a question. Well, the remaining two topics I want to cover with you arise out of the evidence which you gave to the Bergen inquiry. And what I'm going to do, Mr. Barton, is I'm going to show you your evidence. I'm going to ask you to read it. They're only short passages, and then I'll ask you some questions, okay?
Yes.
Operator, can we call up document BGN.0002.0001.2853, please? Thank you. Now, if we can just scroll up a little bit, or down a little bit, sorry, down. Just stop there. Oh, doesn't matter. You'll see, just stop there, please. No. All right. Mr. Barton, what I'd like you to do is just to read the transcript that is on the screen. Up to and including the word Commissioner Yes. Do you see that?
At about paragraph 29 or line 29.
Correct. So just read up to and including 29.
Yes.
If I asked you those same questions today, would you give the same answers?
Yes.
Thank you. And finally, operator, can we please just further on in this document at dot 2870? Thank you, Mr. Barton. I'd like you to read to yourself this whole page and just tell the operator when you want him to scroll.
Yes, it's scroll up. Yes, scroll. Yes.
Now, this can be summarised as follows. Tell me if you agree that you put up a board report to Crown Resorts dated the 10th of September 2020. I can take you to the document. Do you recall the document, or would you like to see it?
No, I recall the document.
Right. And you proposed a restructuring in that document, did you not?
Yes, I did.
And as the transcript suggests, that restructuring saw two roles being removed, namely the CEO Australian Resorts and the Chief Legal Officer Australian Resorts, correct?
It's a restructuring that created new positions and removed existing positions.
Correct. And they're the two positions that were existing that were to be removed, correct?
Correct.
And they were occupied at the time by Mr. Felsted and Mr. Preston respectively, correct?
Correct.
And as you indicated down the bottom answer, this was a proposition that you were putting forward to the board at the time, but the board had not yet agreed to that, correct?
That's correct.
You subsequently did put it to the board, and the board did accept your recommendation, correct?
That's right.
And that resulted in the positions, the then existing positions of CEO Australian Resorts and Chief Legal Officer Australian Resorts being made redundant, correct?
Well, those roles didn't exist in the new structure.
Right. And as a result, both Mr. Felsted and Mr. Preston left the employ of Crown, correct?
Well, they did leave the employment of Crown, yes.
And they did so on the basis of redundancies, correct?
Yes, that's correct.
And so would you agree it would be wrong for anyone to suggest that either of those gentlemen left Crown for any other reason other than that their positions had been made redundant?
No, this was an organisation structure that was driven by some imperatives that were coming from the work we were doing through the course of the restructuring.
So to be clear, when you say no, you were agreeing with the proposition that it would be wrong for anyone to suggest that they left the employee for any reason other than the structural reorganisation that you've referred to.
Yes.
May it please the Commission.
Thank you, Mr. Penglis. Other applications? Mr. Evans.
Just a couple of topics, if I might, Commissioners, largely to see if I can clarify a couple of things that Mr. Futrell took Mr. Barton to. Mr. Barton, my name is Evans. I act for the Gaming and Wagering Commission.
Sure, Evans.
You were taken by Mr. Futrell in the last part of your evidence to the presentation that you made to the GWC on the 15th of December 2020. You recall that?
Yes.
Now, you accept from your decade with Crown Resorts that casinos are a regulated industry,
Yes.
that they are a heavily regulated industry,
Yes.
that it is necessary in a regulated industry of the nature of a casino that there be a relationship of collaboration to a degree, but in particular openness and transparency on the part of the regulated party. Is that correct?
Yes, I'd agree with that.
Now, or I should say more properly, Crown Resorts was aware from August of 2020 that there was sufficient information in relation to the structuring of transactions in the Riverbank and Southbank account to require an AUSTRAC report. And my learned friend Mr. Futrell took you to the AUSTRAC report, which was made in August 2020.
Yes, I've seen that letter now.
Yes. And you accepted in your evidence in the Bergen inquiry that it would have been of significance for the Victorian regulator to be advised that there was structuring in those accounts. Do you recall your evidence in that regard?
No, not specifically.
Can I bring up BGN.002.001.2814 at 2846, lines 15 to 25? Can you scroll down? Can you scroll back up again, sorry? No, I appear to have the wrong reference. My apologies. I'll withdraw that question. It is apparent, however, that by the middle of November, that is the 16th and 17th of November, the company had in its possession, and you read shortly thereafter, the initialism of the Grant Thornton reports. Is that correct?
I think it was, yes, mid to late November, yes.
Did you give consideration at the time to the disclosure of those matters to the VCGLR or the GWC?
I didn't personally, but I know that the relevant executives who had the relationship with both commissions gave consideration to it.
And despite those considerations, at least in the case of GWC, no disclosure was made until the eve of your presentation on the 15th of December, was it?
No, I understand those reports were provided some 3 to 4 weeks later.
Yes. At 5:15 p.m. on the eve of a presentation that you were to make a
Yes. Yes.
Now, you indicated that was not a prepared presentation. Do you mean by that there was not a slide deck for it?
We didn't work off a slide deck from what I recall. There was an opportunity for Ms. Coonan, who I think was for the first time meeting with the Commission, to introduce herself. And then, as I recall, we asked the Commission if there was any issues they'd like us to address. And the only matter that we discussed was an update on the reform agenda.
You did work off speaking notes, didn't you?
I basically worked off my understanding of where we're up to in terms of the reform agenda.
Can I bring up CRW.513.021.3859? Do you recognise these as briefing notes which were prepared for the purposes of that presentation?
I see the heading, and I don't specifically recall it, but I would have expected that a document like that would have been produced.
And it allocates time effectively between Ms. Coonan, Mr. Poynton and yourself,
Yes.
with her speaking first, then Mr. Poynton, then yourself?
Yes, although Mr. Poynton didn't attend that meeting.
I think you mean Mr. Preston, don't you?
Sorry, it was actually Mr. Poynton, I think, was scripted
Yes.
as Mr. Poynton.
Yes, although Mr. Poynton had another commitment and he wasn't able to make it.
If you roll down, that's my understanding of Mr. Poynton. So if the operator can just roll down. That was the intent. That was the intended messaging by Mr. Poynton, which he didn't ultimately deliver. Other than a reference in those prepared notes to the Riverbank account being closed, there is no notes for discussion which would indicate that Crown had at that stage had for more than a month a report indicating that there was structuring of money laundering transactions in the Riverbank account. Is that correct?
The report was probably under a month, but no, there's nothing in those notes from what I can see that talks about the outcome of the external reviews.
And to your recollection, it was not something that was volunteered by either Ms. Coonan or yourself?
Not that I can recall.
No, thank you. Can I move to another topic? And again, it's something Mr. Futrell has taken you to, but I just want to go into a little more detail if I could. You gave in your statement a number of places the assertion that Burswood Limited effectively provides board oversight of the operations of the Crown Perth business unit. You recall that?
Within the Crown Perth group, yes.
Yes. And the Crown Perth group, for that purposes, is Burswood Limited and its subsidiaries, relevantly Burswood Nominees, Burswood Resort Management, and including Riverbank?
Yes.
For that purpose, we know from previous witnesses and from your own evidence that there are information packs provided for the board for the meetings which are held roughly 4 times a year. You're familiar with those?
Yes.
From your roles as Chief Financial Officer for most of the period and CEO, you were a member of the board of Burswood Limited for much of the period of 10 years from 2010 to 2020?
Yes.
And for most of that period, the board comprised the 2 most senior executives of Crown Resorts Limited and the most senior executive of Crown Perth.
Yes.
And for the latter part of that period, the most senior executive of Crown Perth was also a senior executive of Crown Resorts.
Which period are you referring to there, Mr. Evans?
From 2010 onwards. From 2013 onwards, when Mr. Felstead assumed an Australian Resorts responsibility.
Yeah, so from 2010 to 2017, it was Mr. Craigie.
Yes.
And then from 17 to 20, it was Mr. Alexander, who was the executive chairman.
That's right. You're with yourself for much of that period,
Yes.
and Mr. Felstead for all that period, or almost all that period.
I think that's right, yes.
And 2 non-executive directors, and we've heard from them. Now, Mr. Futrell took you a series of questions saying that you would look to the minutes to find out what Burswood Limited actually determined to do. Is that right?
Yes.
And you would expect to find in the minutes of that company as a public limited company dispositive resolutions where the company decided to do something in its board.
Yes.
Can I take you to the last board meeting which considered the financial position of the company in great detail for the 2020 year? That's the last meeting which you participated. And that is the board pack for that meeting. For the meeting of 20 August 2013, which is CRW 703.001.3302. Now that's a board pack, the form of which you're well familiar with.
I can see the agenda.
Yes. And it includes as the first item the confirmation of the minutes of the meeting on the 12th of June 2020.
Yes.
Just have to scroll down to find the right page. Yes, but I'm reminded that I'm not sure whether, given the audio visuals, this document is going out on the public screens as well, but if so, previously we've handled this on private screen.
You manage that.
Thank you. If I can take you down to the minutes of the previous meeting, which was the June meeting. Which commence at page 3304. And you'll see at the June meeting, your record as being present at that meeting. Do you recall it, Mr. Felstead?
Yes, Mr. Barton. Yes, by WebEx.
Sorry, Mr. Barton. And in the usual way, that goes through the financial results for the period to date. It goes through the CEO's report. goes through developments, goes through an internal audit report which Mr Preston presents. And the first resolution one reaches there is 5.1. The board resolved to recommend that an audit charter be approved by the Burswood Nominees Limited Board. That's at page 3307, you see that?
Yes.
It's not a resolution that the charter be adopted, it's that the BNL board adopt it. Now, the BNL board, of course, comprised the three executives, is that correct?
That's right.
Yes, who had recommended the adoption of that charter. And again, if one goes down to 6.2 at page 3308, the other resolution is to recommend that a policy be approved by the Burswood Nominees Limited Board. That's the delegation policy.
Yes.
And just to understand, the delegation policy actually determines who can do what within the organisation. That's who can spend money, who can authorise various activities to be undertaken.
It's limits on what can be contracted on behalf of the company.
That's right. And the only other business is the formal business of adopting the AML compliance certificate and the deed of cross guarantee to participate in the consolidated group. Now, the substantive business of this meeting wasn't it, to consider the financial results of Crown Perth to the period 30 June 2020. This commences at 3311. And that would be the usual practice, would it not, for a board meeting following the end of the financial year to consider the financial results?
Yes.
And it's a lengthy document. But what I want to take you to is I want to take you to the minutes of this meeting, if I can. And they're the minutes of the meeting of the 13th of August, which are CRW.702.001.5829. And again, you're recorded as being there.
Yes.
Again, speak to financial report and so on. What I notice in reading through these minutes, Mr. Barton, is that there is no resolution to adopt a budget or financial plan for the following financial year, that is the 2021 financial year or the following financial period. You recall that there is no such resolution?
I haven't gone through all the minutes, but I don't dispute that.
That would, in fact, be the norm, wouldn't it, that Burswood Limited didn't adopt a budget for the business unit?
Well, they were presented with a plan. I'm not sure if there was ever a resolution to accept it.
Yes, in fact, when I go down to page 5832, can you look at item number 3? So in relation to the financial plan and the financial 21 budget, Mr McGregor is the Group Chief Financial Officer, isn't he?
That's right.
Notes that he'll provide to Ms Fewster. Now, Ms Fewster was a new director on the board at that point. A separate briefing on the financial plan, which had already been presented to the Crown Resorts Limited Board. That's correct?
Yes, that's what the minutes reflect.
And that's the fact, isn't it? It had in fact been presented to the Crown Resorts Limited Board in its meeting some months before. In fact, at the meeting of the Board of Directors of Crown Resorts Limited on the 16th of June 2020.
That sounds like the right timing for that approval, yes.
And at that board meeting, the Crown Resorts Board had approved the financial plans and budget for 21 to 25, so 21 to 24, and the budget for 21 as agenda item number 4.
I would imagine that would be the case.
Yes, and Commissioners, the reference for that is CRW.507.005.1714 at agenda item 4 with the accompanying documents. So it's the case, isn't it, that that in fact the entire financial planning for Burswood or Crown Perth as a business unit was adopted and resolved at the Crown Resorts Limited Board rather than at the Burswood Limited Board level.
Yes.
And the presentation which was done to the Burswood Limited Board, which was done by way of an extensive slide deck, was simply a subset of the Perth segment of the Crown Resorts Group slide deck presented 2 months previously.
That would often be the case, yes.
The one other item which was considered at the 13 August board meeting, sorry, the 13 August board meeting, was the appointment of new auditors. You'll recall that new auditors were appointed in the court for financial year 2021, Messrs KPMG.
Yes, I recall that.
Now this, again, Burswood Limited is a public company, despite being a controlled public company. It would normally pass a resolution for the appointment of new auditors, would it not?
I think the appointment of the auditors would have been subject to approval of the shareholders at the next general meeting.
Right, yes. The appointment of the auditors had in fact been announced, however, by Crown the preceding day, hadn't it? In an ASX announcement.
Oh, I don't recall.
If you don't recall, that's fine. Can I then actually take you to the financial presentation? Because I just want to understand a couple of aspects of it. Now, in document CRW 703.001.3302, which is the pack for the board meeting, on the 13th of August, item 2 is the financial results for the full year, and they commence at page 3311. And again, we need to make sure these are off screen if we can, as a private screen only. Thank you. Can I take you down to page 3312? Now, again, from your time as Chief Financial Officer, you are well familiar with this form of reporting for the financial year, Mr. Barton?
Yes.
And there is a very granular analysis in this page on a consolidated basis. I think that's a consolidation of all of the operating units of Crown Perth under Burswood Limited.
Sorry,
Yes.
is that all or not all?
All of the, yes. All of the operational businesses. I gather there are companies within the group that are not operational, but these are the operational business units.
Yes.
So it includes the gaming business, the hotel business, the convention centre business, and so on.
Yes.
And in the first part of that page, there is an identification of the principal sources of revenue: table games, gaming machines, food and beverage, conventions and entertainment, hotel operations, other non-gaming operations, and support departments, each of which has an ascribed revenue.
I'm sorry, what was the last part of that question?
Each of those has an ascribed revenue for the actual and budget to 30.
Contribution rather than revenue, Mr. Evans?
Contribution. So the contribution is assessed on the basis of determining income minus expense.
Correct, revenue less cost, yes.
That's right. And then following that, there's what I assume is a deduction for the support departments, as they're regarded as being an overhead cost of carrying on business.
Yes, that's right.
And on that page, you can see what's local contribution. Am I right in assuming that's the gross contribution from the Crown Perth business unit?
Gross before interest and tax and depreciation.
EBITDA, effectively.
Yes, yes.
Thank you. And it's apparent on that it's a profitable business even in difficult times.
Yes.
There's lots and lots of detail that follow, and I won't take you to it because in many cases it is repetitive, and in some cases it's granular beyond relevance. But I do want to take you to the balance sheet for, again, the local business unit, which is at, if I can get down to it, uh, 3340. So again, perhaps that can be blown up just a little more for Mr. Barton's assistance. This effectively is the balance sheet of assets and liabilities for the subgroup comprised Burswood Limited and its subsidiaries.
I would say based on that description, that's right.
Yes, all right. So one can see in the normal way, current assets, cash and cash equivalents, etc., non-current assets, which include property, plant and equipment, so that would be the hotel, the physical buildings and the infrastructure within them for the conduct of the resort.
Yes.
A value ascribed to the licences and mastheads called the casino licence and some other things.
Yes.
Below that, there are current liabilities in the usual way, things you have to pay to keep going in business, including tax. But can I take you down to non-current liabilities? And can I take you to the third and fourth lines in non-current liabilities?
Yes.
A non-current intercompany payable loan from PBL WA Pty Limited. Commissioner Owen suggested the other day that might be Crown WA Proprietary Limited now. Do you know which company that is?
Yeah, that would be PBLWR. Actually, it would be Crown Western Australia, which I think is the intermediate company between Burswood Limited and Crown Entertainment Group Holdings.
That represents a loan from that company repayable by entity or entities in the Burswood Limited group.
Yes, that's the way I'd read that.
And then the following line is a non-current intercompany payable loan from PBL Finance. You know what that company is?
Yeah, PBL Finance is not a company that's used typically. I think both of those lines should probably read Crown rather than PBL. I'm not sure what the historical reason for that is, but most of the financing within the Crown Group goes through Crown Group Finance.
Yes, when I looked at your annual report for 2020, the corresponding period, there is, in fact, a couple of historical publishing and broadcasting limited companies in that
Yes.
report, including a PBL CI Finance Proprietary Limited, which ordinarily would be a Cayman Islands company, but it's an Australian company, and a Publishing and Broadcasting Finance Limited, also an Australian company. But you said it should probably be Crown Finance or Crown.
I'd say that's probably a legacy description on that line.
All right. Now that's expressed as a negative number, which means that rather than being money owed by Burswood Limited to that company, it's money owed by that company to Burswood Limited, isn't it, or Burswood Limited Group?
That's the way I'd read that, yes.
Yes. In fact, to the point where in these consolidated subgroup accounts, total non-current liabilities are negative, and liabilities, in fact, become an accrual to net asset, to total assets.
Yes.
Thank you. And that's because of something which Mr. Futrell took you to earlier, which is the notion of a Crown sweep, or a sweep of the accounts on a periodic basis. Is that right?
It could be that, or it could be loans that have been separately made from the Crown Perth Group to Crown Group Finance.
Can I take you down to page 3341? This is a cash flow report for the 2019-2020 period. Gain report as part of the results. And if I can take you towards the bottom of that, there is a line, repayment of borrowings, PBL finance. So on a periodic. Now, do you know if that is in fact a repayment of loans or a sweep of surplus cash?
Given it's negative, it looks like it's, and given the balance of PBL finance or Crown Group finance, those look to be loans being made to Crown Group finance from Crown Perth.
Thank you. No further questions. Thank you, Commissioners.
Thank you, Mr Evans. Are there any other applications?
There is, Commissioner, yes.
Mr. Sorry.
Thank you, Commissioner. Mr Barton, my surname is Garris and I act for the Crown Companies. In your statement, you explained that AML was not part of your role as CFO, but that following your appointment as CEO in 2020, you worked closely with the AML team on expanding and improving management of the AML risk. Can I ask you to outline the major steps that you implemented before your departure from Crown on AML and more broadly what's often referred to as the remediation program? And can I invite you to in particular address these topics, structural reform and personnel and culture?
Structured personnel and culture?
Yes.
Yes. I think one of the most significant changes that was implemented last year was to move the regulatory and compliance functions from within the business unit to be a standalone function outside the business units, the operating business units. And that was announced late last year, a new financial crimes and compliance function that would have direct accountability through to the board. And that would be led by a very senior executive out of the banking sector with significant financial crimes experience. And we'd also have carriage of all of our compliance matters. And the important feature of that structure is it creates a direct line of accountability without having any revenue or business unit oversight. And so those compliance and regulatory functions can be kept away from the business unit and have a completely independent view. We've also added an independent internal audit function that again has a reporting line outside of the operating business units through to the audit committee and the chief financial officer. And so in the classic model of three lines of defence, with the first line of defence being around the organisation, I'll come back to culture. The second line being a regulatory and compliance function, and a third line being an internal audit function. In the case of the second and third lines of defence, in both of those cases, they are now outside of the operating business unit, having reporting and accountability through to the board. So that was the structural change that we implemented at the end of last year. The other change was to have the promotion of the heads of the properties to be at the CEO level. So there are now 3 property level CEOs who've got basically CEO responsibility for the 3 main casino properties. In terms of other structural changes within the AML department, there was some additions to people. So that function grew. By the middle of last year, the headcount, although positions were still being filled, was at 15. And in particular, there was an increased analytical capability that was built into the AML team, and that was supplemented by a series of projects to create technology that would support the roles and functions of the AML team. In particular, and I think it was mentioned before, the Sentinel project, which came online through the course of last year, which gave an automation to the processes around the transaction monitoring program, but also gave us access to information around the patterns of play and other intelligence around information that could be obtained through Crown's various reporting systems. So information from Psycho and other places was imported into the Sentinel system, and then screens and rules were run across that data to enable more visibility and transparency around the AML reporting, as well as an automated or an online capability to have a streamlined reporting of what were called unusual activity reports. So anything which came to the attention of people in the organisation at whatever level could be quickly captured with what's called UAR, or unusual activity report, which was then fed into the AML team for review and triage, and basically dealt with in whatever form the program required. I think that was structural. In terms of personnel, Mr. Garris, as I mentioned, we've Crown recruited and announced at the end of last year that Mr. Steve Blackburn, who was the former head of AML at National Australia Bank, was appointed to lead the financial crimes and compliance function within Crown. There was a new role created, the head of people and culture, which was important from the cultural aspect. That role was filled by Mr. Tony Weston, who's now commenced with the group. And there's been a recruitment since I left of a new head of internal audit, who's in the organisation as well. In terms of culture, there were some steps taken towards the end of last year. Deloitte was appointed to do a review of Crown's culture. Some of that work was, I think, discussed through the course of this meeting, and work was undertaken to review the culture, meet with the top executives, and also to start getting some of the cultural aspects from the board message through the organisation. So there was a work plan that was put together towards the end of last year on some steps to be taken outside of the Deloitte work to move towards a program to identify the existing culture, some work to be done to look at where there were gaps in the culture, and a plan to address those gaps. And that work commenced at the end of last year.
Thank you. Now, what was the length of time you estimated it would take to fully implement that remediation program, if such an estimate was made?
There was no estimate made of how long it would take to undertake all of those tasks.
Okay, then at the time of your departure, which was February of this year, how far had the remediation program progressed? And in your view, what further measures needed to be taken?
Well, the program was underway across all of those areas. Some of the immediate steps were implemented, particularly around things like incentive programs, particularly around some of the AML functions. So some of the AML work had been done, but I think there was a recognition that that the AML improvements would need to be reviewed by Mr. Blackburn once he commenced. So there was work that we could do which was obvious and immediate. Those things were being done around the organisation structure, the personnel, the capability, the technology. So those were being implemented at the time, and some of those were advanced, but there was always an expectation that those plans would need to be reviewed once Mr. Blackburn started. The culture program was really in its infancy. That was only just getting started, and it was really an expectation that would be driven with a lot of support from the new head of people and culture.
Thank you. Now, moving on to a new topic. In your experience, did the Crown Group operate in a way that corporate groups typically operate, at least in most respects?
Sorry, Mr. Garris, could you perhaps...
So there's been a lot of questions about the decision-making either at Crown Resorts level or at the property level. In your experience, as a corporate group, did this group function in the usual way in which corporate groups operate?
Yes, I think the corporate function was quite typical of a corporate function. and the operating business unit's decision-making at an operational and business level was consistent with my experience.
I've lost Mr. Barton temporarily. Mr. Barton, you froze for a minute. Can you hear me now?
Right. Yes, I can hear you.
Thank you. Now, again, in your experience, and I'm asking in general terms, can an organisation or a business benefit from being part of a larger organisation or group?
Oh, yes, it can.
And I'll come back to that topic, but during your time as CFO, you oversaw several major developments, including the Perth Crown Towers development and other major improvements. Now, I think you mentioned previously that you understood the budget in relation to Crown Towers was about $650 million. Is that correct?
I think that was the final cost, yes.
And you're aware that there are other developments that totalled into the hundreds of millions at the complex?
Yes, I think the total capital expenditure in Perth over the 10-year period was something like $1.4 billion.
Thank you. And in your experience, was there ever any suggestion that Crown Perth's interests or business should be subordinated to that of Crown Melbourne?
No. In fact, Crown Towers Perth was the biggest single capital investment from within the Australian resorts business, obviously excluding Crown Sydney, over that time. And the capital expenditure in Perth, which was a smaller property and generated less revenue than Melbourne, was roughly the same as the capital expenditure in Melbourne over the last 10 years.
And now coming back to benefits of being in a larger corporate group, in your view, has and does Crown Perth, or has it benefited from being part of the Crown group of companies?
Yes, it has. Yes, that would be my view.
Can I ask you to address any some particular topics, like branding and corporate support at head office?
Yes, the Crown brand was taken to Crown Perth, which used to be the Burswood Entertainment Complex. Being part of the Crown Group meant that in areas like hotels, there was the ability to market multiple properties in terms of branding with the 3 properties in Australia, plus historically a presence overseas. It meant that being able to market the hotels as under the Crown brand certainly had value. The ability to leverage off relationships in areas such as food and beverage to be able to bring food and beverage offerings to Crown Perth was a benefit that came from that aspect of the business. Plus also the ability to leverage some of the capability at a group level around some of the support functions such as technology, marketing, and other areas.
Thank you. What about efficiencies in relation to costs? Economies of scale?
Yes, so to the extent that we could, the Crown could bring support functions, which are a cost centre, into one location and leverage the scale that comes with bigger functions that would have certainly existed in areas like back office accounting, finance, in technology, the ability to leverage one core group of IT executives, in procurement and purchasing, in the scale that you get from having multiple properties, so that the cost of purchasing and the benefits of scale purchasing would translate to Perth as well.
Thank you. What about efficiencies and quality of compliance?
Well, I think compliance historically has been a property level function, mainly because the difference in regulations across both jurisdictions as it relates to casino regulatory, but areas like AML, which is a national compliance obligation, there's benefits from having a single location from 2 respects. One is building capability and attracting the right calibre of person from a larger scale employment opportunity, plus also the ability to leverage technology and developments across multiple properties rather than having to recreate the wheel in each jurisdiction.
Thank you. What about responsible service of gaming?
Yes, again, a little like AML, there's a lot of commonality across the casinos on the benefits or the right approach to responsible gambling, and having a team in one location who can invest the time and resources into developing RSG capability could be leveraged across multiple properties.
And lastly, corporate social responsibility.
Yes, again, programs, particularly around employment opportunity, equal employment opportunities, gender diversity, Indigenous employment. A lot of those programs can be developed in one place and made available to multiple jurisdictions.
Thank you, Mr. Barton. Commissioners, I have no further questions.
Thank you, Mr. Garris. Any other applications? I know we have some people that are not present in the room. No? All right. Commissioner Jenkins.
Thank you, Mr. Barton. I have some questions for you. In respect to the ANZ Bank, could you clarify for me, was Crown Perth banking with ANZ before the River Bank account was opened in 2014?
I believe it was. There was a Burswood nominees account with ANZ, which I think existed before the 2013 account opening.
And that was the Perth Casino's main operating account?
I don't know precisely, but it certainly was an account that was open. I know that it was available for patron deposits. It may have also been used for other transaction banking as well.
So at paragraph 36 of your statement, you say that you were the primary contact for Crown's relationship with ANZ. Does that mean that when Crown opened the account, the Riverbank account with ANZ, you would have been the primary contact person?
My relationship with ANZ was, in my capacity as CFO, more around the capital markets or the debt side with ANZ rather than the transactional side. So the discussions I would typically have with ANZ would be around some of our banking, access to debt capital markets and their ability to provide funding to Crown. I didn't have a lot of discussions with ANZ or any ongoing dialogue with ANZ around the specific banking accounts and transactional banking.
Yeah, in 2014, when ANZ expressed concerns about the account, the Riverbank account, you did have quite significant contact with them.
Yes, Commissioner. As from a relationship perspective, I think it was important that they wanted to raise with me those concerns.
But you have no recollection of having that kind of contact with them when Crown opened the account, the Riverbank account?
No, not that I.
In respect of the financial and operating aspects of the Perth Casino, in general, what regard was had to the requirements in the Burswood Property Trust Deed in respect to accounting for the finances of the Perth Casino and in terms of operating the Perth Casino?
I'm not familiar with what the accounting between the various subsidiaries was. That was a matter that was managed within the Crown Perth finance team.
So Do you recall ever reading the Burswood Property Trust deed?
Not that I can recall.
You said that surplus funds in the Perth Casino bank account would have been transferred or swept up to the group level. Is that your evidence?
Yes.
So do I take it from the fact that don't recall having read the Burswood Property Trust deed, you wouldn't know whether that was in accordance with the requirements of the trust deed
No.
in terms of dealing with net income was to be distributed?
No.
In respect of the cross guarantees between the various entities in the group, can I ask you whether you know whether in Victoria, if Crown Melbourne was a party to those cross guarantees, ministerial approval had to be obtained for that commitment?
So the two being guarantees of the banking facilities and under the asset class order.
Yes.
I'm not aware whether ministerial approval was required.
Do you know whether Mr. Costin still works for Crown?
Yes, he does.
In what role?
Group treasurer.
And do you know whether Mr. Taylor or Tyler, I'm not quite sure if I've pronounced that correctly, Theiler, still works for Crown?
No, he doesn't.
In answer to a question from Mr. Evans, you agreed that Crown Perth was a financially profitable business even in difficult times. Can you tell me, is that the case even without ICB, that is International Commission business?
Yes, it is, Commissioner.
And in respect of the conversation you had with Mr. Brown about structuring occurring in the Riverbank account, can you clarify or tell me when that occurred?
It was after Mr. Preston's evidence, which I think was in around August
2020.
August of last year, and the aggregation issue was identified or was flagged through the course of that evidence, and it was sometime shortly after that.
And in that conversation, did he or you discuss whether further inquiries should be made as to why it had occurred?
I don't recall if we had that discussion.
In respect of that, in essence, in 2014, when ANZ closed the account, you knew that ANZ suspected that some of your customers were money laundering at the Perth Casino. Is that right?
They had concerns about structuring in the account.
And they had concerns about that because it was an indication or a possible indication of money laundering.
Yes, that's right.
And that was money laundering at the Perth Casino.
Yes.
And as CFO, the result of that concern being expressed to you was that you did nothing to prevent those patrons who were so suspected continuing to do business at the Perth Casino. Is that right?
Well, there was the steps taken to understand the basis of ANZ's concerns, which was a review that was, or some questioning that was made of the CFO of the Perth Casino. and then further the engagement of the AML team for them to respond to or deal with the concerns raised by ANZ. So I think the requirement would be that if we become aware of issues around AML, to raise it with the appropriate team within the business that's got carriage of AML matters, which was the AML team within both Crown Melbourne and Crown Perth.
But in answer to my question, you did nothing to prevent those customers continuing to do business at the Perth casino.
No, I didn't. No.
And as far as you're aware, Mr. Tyler did nothing, Mr. Costin did nothing, Mr. Brown did nothing, and Mr. Preston did nothing to prevent those patrons who were so suspected from continuing to do business at the Perth casino.
That's right.
And then in respect of the question of the aggregation of the accounts, or put that to one side, in respect of who in the finance team or in the cage team at Perth Casino had not brought these suspicious transactions to the attention of more senior management, there was no investigation done to ascertain who those people were.
I'm sorry, Commissioner, I'm not sure about that question.
There was no investigation done to see who in the finance team or the cage had failed to bring to the attention of senior management these suspicious transactions.
In 2014?
2014?
Well, what I don't know, and I guess it's careful territory, is in 2014 what the AML team did in relation to those matters.
So you don't know that anything was done to ascertain who those people were and why they had not brought the transactions to the attention of senior management.
Yes, I don't know whether the AML team had under the program.
I said that. I'm asking you for your personal knowledge at this time.
Yeah, no, I don't know.
And indeed, won't follow that up. Were you aware that in May 2018, Mr. Poynton entered into an agreement with CPH in respect of services he was providing to them? I shouldn't say he, because it was his family company that did that.
I was aware that Mr. Poynton joined the board as a representative of CPH. I don't know if I recall what knowledge I had of his contractual arrangements with CPH.
Did you know he had a contractual arrangement with CPH?
I don't recall whether I had that knowledge.
In 2018, 2019, the Bergen report says that you were under pressure from Mr. Packer to meet budget and to reduce costs in the Melbourne and Perth properties in order to meet budget. Do you agree with that?
Certainly there was always a focus on achieving budget. I don't recall if that conversation extended to whether that was going to be achieved by reducing costs,
or increasing revenue?
or well, it could be either.
In the Bergen report, there's a reference at page 201 to Mr. Johnson sending you an email on the 21st of May 2019, which refers to an assumption of a more significant impact from the Tap and Go initiative for the financial year 21 and beyond at the Perth Casino. Do you have any recollection now as to what the Tap and Go initiative was back in 2019 for the Perth Casino?
No, other than if it was the use of FPOS cards at gaming tables to buy in for chips.
So what I'm really interested in, Mr. Button, is whether that was under consideration in May 2019 within Crown.
I don't recall.
And finally, you said that you have a consultancy agreement with CRL, and could you tell me whether you will be paid by CRL to prepare your witness statement in respect that you've provided to the Commission?
It's not a consultancy that's based on any particular work product. It's a consultancy to be generally available.
So you get paid according to the consultancy agreement, whether you perform work or not.
That's right.
And so you get paid on the basis that you're available to do what?
Provide any assistance to Crown that they require.
And how do you know whether you're required to do something or not?
Sorry.
Sorry?
No, I was cutting over you. Sorry.
So my question was, how do you know whether you are required to do something for Crown or not?
I'm available for anybody from Crown who wishes to engage me to do any work. I'm in discussions with people at Crown from time to time, but it's known that if there are specific pieces of work that are required that call on my knowledge and experience, that I'm available to do that.
Thank you.
Mr. Barton, I only have one question for you, or two actually. In your exchange with Mr. Garris about the group structure, that Burswood operating within a group structure and the efficiencies that could emerge from that, I'm wondering if then when Commissioner Jenkins asked you if you'd read the Burswood Property Trust deed, if having drawn your attention to the fact that there is this rather historic, that there's this historic structure which the PBL entities inherited, whether the existence of the trust makes this a little bit different from a normal corporate group operation. That's the first question. And the second question, the other point of difference is, or for your comment, is whether or not the fact that at the end of this chain of companies is a licence, and it's a very particular type of licence, which carries with it obligations to the state of Western Australia, whether that would impact on your thinking on the normality of the operations of Crown as a group structure.
Yes. If there are specific provisions in the trust deed that go to the question of where work or service is performed, I'm not aware of that, so I'm not sure if the trust itself creates any different treatment. In relation to the obligations to Western Australia, I think my observation would be that the functions that are being, if you like, combined across the group are by and large support functions. And so the decision making, the optimising of the business and the operations is really within the remit of the head of the Crown Perth business, the now CEO of Crown Perth. They have the opportunity to draw on the services that are provided on the group. And so if they choose to accept some of the support, they can choose to or choose not to. And that's around areas like marketing, IT, where that's available. There's local IT capability. There are some parts of those functions that are for efficiency purposes and for consistency purposes rolled out on a group basis. But those are available to the Crown Perth business to draw on. But ultimately, the decision on whether to use those services rests with the leader of the Crown Perth business.
Thank you. And my other question relates to the topic that both Mr. Futrell and Commissioner Jenkins have explored with you, and it's the around September 2020 reaction to the knowledge that you'd gained that the Riverbank accounts had elements that suggested structuring, and taking that back to 2014 to a similar knowledge. I'm not suggesting directly to you, but that there was a knowledge in officers of Crown of the same problem, that there were elements of the Riverbank account that were indicative of structuring. Do you accept that premise?
Yes.
You said in relation to your conversation with Mr. Brown that there was, you can't recall any discussion about making investigations as to staff members who might have failed to bring matters to the attention of senior management. But if we go back to the response of Mr. Costin in that email that's been shown to you today, where he says, please let the patrons know that they are not to deposit cash under $10,000. That appears from that email to be the only instruction given. And so my question to you is, given that, or I'll ask you whether you accept that an AML program that is going to work depends on it being imbued not just with management, but the people on the floor. Do you accept that?
Yes.
Given that, would it not have been appropriate? I'm sorry, I'll ask you the question. Are you aware of any instruction being given to, as a result of what the ANZ Bank had disclosed to you, to any instructions to staff members to increase their level of vigilance on these matters?
I'm not aware.
I am talking about 2014.
Yes, I'm not aware.
And as you sit there now, and because in your third statement to in the Bergen inquiry, you've indicated areas in which the response could have been better. Is that another one that could have been done at the time?
Yes, it could have.
All right, thank you. Ms. Boris, do you wish to re-examine?
Thank you, Commissioner. Just one or two questions. Mr. Barton, you were asked earlier by Councillor Sisting about a letter that went to the GWC on the 14th of December, which attached, amongst other things, a report by Initialism. Do you recall that?
Yes.
And that was a report which, well, there were two reports, but the Grant Thornton and the Initialism reports were both reports in relation to the transactions in the Riverbank and South Bank accounts. Is that right?
That's correct.
Was that the only work that Initialism was undertaking for Crown?
No, they were also undertaking a broader review of the AML processes, including a look at how information was introduced into the AML processes, so the way data was collected and input into the transaction monitoring program, and also a specific piece of work around a root cause analysis of why the aggregation issue occurred.
I'll come back to that in a moment. I'm sorry, Commissioners, that the document by which Initialism was engaged, I don't believe is in the hearing book, but I can arrange for it to be provided to the Commission. So given that there was all this work that Initialism was undertaking, how were they prioritising that work?
From what I recall, the priority was given to the detailed review of the potential for structuring transactions within the South Bank and Riverbank bank accounts. So that was the first priority. And then following the completion of that work in November, then the next piece of work they were engaged to undertake was around the potential for those types of transactions to be identified in Crown's other bank accounts outside of South Bank and Riverbank. So those were the two main priority tasks.
And who formally engaged Initialism?
That was Minter Ellison.
Okay, so were Initialism and Minter Ellison in discussions about the priorities of these tasks?
I believe so.
You were asked some questions by Mr. Futrell and again by Commissioner Jenkins about, and you mentioned also a moment ago, a root cause analysis. Now, as I said, this document isn't unfortunately before the Commission, so I can't call it up, but I'll read something from this. And does this correspond with what you mean by this? I'm reading from the letter of engagement from Minter Ellison to Initialism in October 2020, which has 8 tasks in it. And the third one is undertake a root cause analysis of the failure to identify and/or non-escalation of potential structuring to avoid threshold transaction reporting requirements. Is that what you were referring to when you said something about root cause analysis?
Yes, that's right.
And you mentioned in response to a question from Mr. Futrell that work had been commissioned. Did you see the outcome of it?
No, to my recollection, it wasn't complete when I left.
And do you know why that was?
I think it was a question of priorities. I don't think that even completed the second stage of work, which was the review of the bank accounts outside of South Bank and Riverbank.
Thank you. Moving to another topic, you were employed by Crown over a decade, and for the first majority of that period, from 2010 until January 2020, you had one role, which was CFO, and then for about a year after that, till February 21, you had a different role, which was CEO. You've given evidence about that. In your first role, so that first large chunk of that decade up until January 2020, when you were CFO, did that position have any responsibility for anti-money laundering?
No, it did not.
And you've mentioned a lot of times in your evidence that there was AML teams in the properties. Did those teams report in any way through to the CFO?
No, they did not.
And you've given evidence in response to a question from Mr. Futrell about your experience and training in the field of AML and how you had become more familiar with AML in recent times. Did that correspond with your becoming CEO?
Yes, most certainly.
And when you were describing in response to a question from Mr. Garris, the reforms that you introduced to respond to AML and other issues in your role as CFO, you mentioned separation from operations of the AML function. Was that, did I understand that correctly?
Yes, as CEO, one of the significant changes was to separate and elevate the AML, the financial crimes, and the compliance functions from within the business unit to have clear accountability and transparency through to the board of directors without having any operational oversight.
Thank you. I have no further questions, Commissioners.
Thank you, Ms. Morris. Mr. Barton, thank you very much. That has been of great assistance to us. We're grateful to you. There may be tidying up to do, so we'll leave the summons in place, but yeah, you are now, that completes what we need for the moment. Thank you very much. And we will adjourn until 10 a.m. 10 a.m. tomorrow. Thank you.
All rise.